Stand before you, I'm saddened to report that the process is still broken. The simple fact is that too many games are being played at the expense of the reputations of honorable men and women who've been asked to serve this nation as members of the federal judiciary. To be sure, the Senate's role of advice and consent is itself inherently political. It requires the action and the vote of a political branch of government. But what is increasingly apparent is that these proceedings see the influence of inside the Beltway interest groups that have decided that no attack is too frivolous and no smear is too baseless to bring against a judicial nominee that they oppose. These groups don't hesitate to turn judicial nominees into caricatures, cherry-picking from their judicial opinions if they've been judges, or misrepresenting the facts of their legal experience. They also end up labeling them pro-this and anti-that, whatever the particular cause. Whatever happened to impartially judging the law and facts and letting the chips fall where they may? That's my ideal of a well-qualified nominee for judge. But consider the case of Judge Leslie Southwick of Mississippi, who's been nominated to the U.S. Court of Appeals for the Fifth Circuit. Judge Southwick served for almost 12 years on the Mississippi Court of Appeals, where he has participated in thousands of cases spanning the gamut of criminal and civil law. He is, by all accounts, a respected member of that court and an honorable and decent man. Notably, he took a leave from the bench to volunteer to serve his nation wearing the uniform of the United States military in Iraq. The American Bar Association unanimously found Judge Southwick well qualified for service on the Fifth Circuit, which, as you know, is the highest rating that the ABA gives. But for whatever reason, this honorable public servant has been dragged through the mud, in my opinion, slandered by his opponents. Judge Southwick has been called an arch-reactionary, a neo-Confederate, and hostile to civil rights. Everything but the word racist, though that has been implied by the attacks. Judge Southwick's nomination has been opposed by most of my colleagues on the other side of the aisle on the Senate Judiciary Committee. But I want to especially note my appreciation of Senator Dianne Feinstein of California, who I think quite courageously declined to be strong-armed by the interest groups who were whipping up manufactured hysteria. Announcing that she found zero evidence to support the charges against Judge Southwick, Senator Feinstein joined others on the committee to advance the nomination to the Senate floor, where it now pens. What was never answered during the Judiciary Committee's debate over Judge Southwick's nomination is why the same panel had, just 1 year earlier, unanimously approved him for a position on the U.S. District Court. I posed the question to my colleagues during the Judiciary Committee meeting. I said, if there's a concern out there that Judge Southwick was not qualified because of some perceived racial issue, why in the world would the opposition deem him acceptable to be a federal district judge? Think about it for a second. The discretion afforded to a district court judge is so much greater than that of a member of an appeals court sitting in a collegial decision-making body. From the start of the trial, from voir dire to juror strikes, through evidentiary rulings and jury instructions, obviously a district court judge has enormous discretion. And I trust that my colleagues would never vote for someone with a perceived problem of treating people unequally based upon their race, and would never confirm them for a life tenure in a role with such enormous discretion. In all fairness, there was no legitimate concern about Judge Southwick's character or record when he was confirmed as a United States District Court judge. It was just the latest incarnation of the dangerous game that's being played out with the reputations and lives of honorable public servants. Senator Mitch McConnell, who is the Republican leader in the Senate, put it this way: when do we stop, for the sake of the institution, for the sake of the country, and for the sake of the party that may not currently occupy the White House? When, he asks, do we stop it? The Washington Post editorial page, along with respected legal affairs columnist Stuart Taylor from National Journal, both lamented the treatment afforded Judge Southwick, who, I should mention, has yet to be confirmed by the United States Senate. Stuart Taylor's column is appropriately titled "Short-Sighted on Judges." He writes, "The long-term cost to the country is that bit by bit, almost imperceptibly, more and more of the people who would make the best judges, liberals and conservatives alike, are less and less willing to put themselves through the ever longer, ever more harrowing gauntlet that the confirmation process has become." I share this story with you in order to impress upon you the kind of gratuitous and personal attacks that are occurring with greater frequency against judicial nominees. And what I fear is, as Stuart Taylor fears, is that if this happens under one president, who happens to be the leader of one political party, it's just as likely to happen when we change presidents and they perhaps are the leader of the other major political party. And so I'd like to appeal to you once again in your individual capacities and as an organization. I hope that you will help, as leaders of the bar, continue to help us and encourage members of Congress to improve the tone and the rhetoric of the judicial confirmation process. When good men and women begin to decline the opportunity to serve on the federal bench out of disdain for this unnecessarily hostile process, the administration of justice in our nation will be the worse for it. I firmly believe that we should consider nominees on the basis of their qualifications and their temperament. We should examine their commitment to applying the law regardless of their personal beliefs. I will conclude with this thought. From my experience as a judge and practicing lawyer, I'm led to the conclusion that one of the things that has damaged our civil discourse the most is the predisposition, and it seems to infect folks who work inside the Beltway more than anywhere else, the predisposition to regard adversaries on a particular point of view or from a particular perspective as personal enemies. One of the things I value most about my legal background and training is the nature of our adversarial court system. While at one time you may be fighting like cats and dogs, not in a literal sense, in a figurative sense, against your adversary in court, the very next case may require you to work together. So too it should be in the Senate. We can certainly have disagreements, and all of us expect that we will argue to the best of our ability to persuade others who disagree with us that we're right. But we must try to maintain a civil level and tone to that discourse. We must keep those disagreements on a par that would tend to engender the respect of the American people and continue to allow us to both recruit and retain good, qualified people for these positions. I, for one, am not concerned that disagreements with decisions that judges have made have any real potential to endanger judicial independence. Let me say that again. I'm not concerned that in the process of confirming judges, that criticizing judges for what they have actually done and said while judges, when being nominated and confirmed to a higher judicial office, I'm not concerned that that has the danger of, that will endanger judicial independence, as long as it's done in the appropriate way. Just as you are free to scrutinize and criticize a vote that I may cast, we should not shy away from critically examining the logic and reasoning of a judicial decision or a judicial writing. Ultimately, the concerns I'm expressing today can be fixed, and I believe it's simply within our power to do so. What is lacking so far is the will. I hope, is